The Presidency has welcomed the dismissal of former President Jacob Zuma's leave to appeal application, the setting aside of his private prosecution against President Cyril Ramaphosa. It comes a day after he failed in his appeal bid in another private prosecution matter related to state advocate Billy Downer and journalist Karen Moon. That is in what Zuma has said was the alleged leaking of his medical records by Downer to Moon. Zuma wants President Ramaphosa charged as an accessory after the fact in relation to that case.
This matter is set down for judgment this morning. We have prepared a written judgment which will be made available to the parties as soon as the proceedings are adjourned. It will also be uploaded to case lines and released to SAFLI. So I'm only reading out the order, and it reads as follows. The application is dismissed with costs.
For more on this, we're bringing in now University of Cape Town Public Law Associate Professor Cathy Powell. A very good evening to you, Cathy. Always get to speak to you. So only the order was read out today. The full judgment will be uploaded onto case lines. How helpful is what the court has shared for us in deciding or figuring out where this leaves Jacob Zuma?
Well, we know where it leaves him. It leaves him about to apply to the Supreme Court of Appeal for leave to appeal to them. For his purposes, he should not be surprised by this judgment. It was, everybody saw it coming. And what he was going to do anyway, which is try to get permission from the next forum to appeal to it. So it doesn't change much for him. Seen the judgment yet, it certainly hasn't appeared on SAFLI, so presumably it's still being processed. But we can get a pretty good idea from the previous judgment of the same court. In other words, the judgment that Zuma wanted to appeal against. That made it quite clear why the court would not tolerate his bringing a private prosecution against Ramaphosa. Made it very clear. So I imagine that the refusal of leave to appeal is simply going to explain why it's unlikely that another court would come to a different conclusion. Right.
And what Jacob Zuma basically went to court for was trying to take Ramaphosa through the private prosecution process for, is what he says was basically a failure to act by Ramaphosa after he says his rights are violated through the leaking of his medical records, allegedly by Billy Downer to Karen Moon, the journalist. But they say, well, that wasn't a leaking because once those records are part of official court documents, they're basically part of the public record, right? So it's not a leak legally. But what Ramaphosa has always been saying from December last year when this first emerged is that he had no place to act. And even in this case, by the former president, at some point, you want intervention from a head of state, but you're taking action against him in his personal capacity. How do the courts even begin to make sense of it?
Correct. Look, it was a very muddled process from the very beginning. It was an invalid private prosecution because Zuma's legal team didn't tick the boxes that have to be ticked before anybody can bring a private prosecution. So before we even worry about whether there was even a crime for Ramaphosa to be an accessory to, before we even look at whether Karen Moon and Billy Downer could validly have been prosecuted, which the court has subsequently said they weren't, before we look at any of that, Zuma's legal team simply had not paid the deposit they're supposed to pay. They hadn't got the certificate from the NPA that said the NPA wasn't going to prosecute this crime. They just hadn't done anything that would actually make the private prosecution of Ramaphosa halfway feasible. It was procedurally completely defective. So what Ramaphosa has been trying to do is to get a court order, and it has been successful, to stop Zuma and his legal team wasting Ramaphosa's time. There were other errors as well. As you said, it's a crime, if it was a crime, that could only have been committed by the president, but they charged him in his private capacity. The summons was defective. And of course, we've discovered now from the ruling of the Pietermaritzburg High Court that Karen Moon and Billy Downer hadn't committed a crime either. Now, the charge against Ramaphosa in Zuma's private prosecution is that he was an accessory to Karen Moon and Billy Downer's crime. Now we know that they didn't commit a crime either, so there's nothing to be an accessory to. So there are so many reasons not to allow the appeal that Zuma is trying to bring to be able to continue to prosecute Ramaphosa.
So how much longer then? How much longer then, Cathy, could he, if he does indeed file an appeal, let's say in the coming days, in the coming weeks, how much longer could this drag on for?
Well, he's got two more forums that he could appeal to, the Supreme Court of Appeal and the Constitutional Court. What he heard today was that the court that gave the first judgment, so the High Court, the Gauteng High Court, refused him leave to go to the Supreme Court of Appeal. That doesn't stop him asking the Supreme Court of Appeal directly, can I bring an appeal to you? But the practice is that if there is an appeal of this nature, a request by Zuma to bring an appeal to the SCA, they will put it up at the beginning, at the top of their list so that it can be dealt with quickly. It is very likely that the SCA will refuse Zuma leave to appeal. At that point, he can ask the Constitutional Court the same thing. It is also likely that they will refuse him leave to appeal. At that point, the whole thing's over. Unless, and we've seen Zuma be incredibly creative before, he starts trying to bring rescission applications and all sorts of things that we've never imagined. But I imagine if the SCA and the Con Court handle this fairly efficiently, we can hope against Ramaphosa is decided in a couple of months. But it's certainly not over yet.
He's also tried, the former president, in the past to basically link the allegations against Downer and Karen Moore, the journalist, as part of a broader case about an unfair treatment of him in the arms deal matter. Do you think that there will be another attempt when that resumes to try and bring these issues into that to stall or block the prosecution of the former president and Thales on the corruption charges?
Quite possibly, because from what I have seen of Zuma and his legal tactics so far, they have been off every bingo card I could ever imagine. You know, walking out of the Zondo Commission, refusing to comply with the Constitutional Court order. The various things that he's done have all been unthinkable. So there may be some more unthinkable things that he will still think of. But it is pretty clear that the prosecution against Billy Downer, at any rate, is aimed at being able to remove him as the prosecutor in the arms deal prosecution of Zuma himself. Now, that's not working, but while he appeals, and I am sure that he will appeal, go through the various forums for the Billy Downer Karen Moore matter, the prosecution of himself, of Zuma himself in the arms deal matter has to wait. So if nothing else, it's a time-saving. He buys time this way. So he's busy appealing the Ramaphosa decision of the High Court, but he's also going to appeal the Billy Downer Karen Moore decision not to let him appeal. And while he does that, the prosecution against him has to wait. I don't know. I mean, your question was, are there further tricks up his sleeve when that route fails, when he doesn't manage to bring a private prosecution against Billy Downer? And I really can't imagine what they are, but I wouldn't put it past him to have some.
I do wonder, though, if perhaps, if nothing else, the one benefit from the Moore Downer case and Zuma versus Ramaphosa, the private prosecution cases, if the one benefit that we've at least had is how it's been allowed, or the cases have been able to allow us to test perhaps some of the limits around private prosecution, because it's not a route traveled by many in South Africa. And in fact, some have argued that unless you've got the means, it's still an avenue that is largely inaccessible to many South Africans. Have we learned anything useful from these cases as far as that?
You know, it's a good question, and I wish we had. But these particular private prosecutions were so obviously defective in so many ways that I don't think the laws developed very much. The requirements in the Criminal Procedure Act for a private prosecution simply were not met. There is a little bit of case law now on whether it counts as leaking to reveal something that's already in the good, and, you know, surprise, surprise, the answer is no, that's not leaking. Beyond that, all the case law has confirmed is that the requirements in the Criminal Procedure Act for a private prosecution have to be met. There was nothing complicated about how they weren't met for all the attempts of the Zuma legal team to somehow muddy the waters. So I wish I could say, yes, we've learned something.
Professor Cathy Powell.
Seen is,
please finish your point, ma'am.
Thank you. What we've seen is what the High Court itself has called an abusive process. So we've seen the private prosecution being used by somebody who has the funds to harass and intimidate and delay. And that is not a happy thing to watch, although it is good that the court refused to let it carry on.
Professor Cathy Powell, good to speak to you. Thank you so much for your time